My name is Hurst Sisodia, and I serve as a primary F1 student advisor for entire MSU. So that doesn't mean I'm the only advisor. We've got quite a few other advisors who deal with F1 visa issues. Some of you may have seen me do some presentation, or we may have seen each other in some other context. But here, we're going to talk about what are you going to be doing as far as employment authorization for while you're studying, and also once you're done completing your program. It's going to be a short presentation. I'm not going to go into every little detail because that would be here for at least a day. Okay? So how you can reach me or anybody, via OISS. Here's the contact number. That's the general number, and you can ask for me or any of the other advisors. If you want to email me, that's fine too. There are never enough questions. So if you email me 20 times, I will respond 20 times. I won't get tired. But I may not give you the answer you want right away. I want you to go ahead and kind of research or read up on it so you retain it much better. So in here, what we're going to cover is going to be about OISS, basic, what does OISS do, understanding work authorization options, and then we'll have an open discussion. Okay? Then Mark is going to take care of everything what happens beyond your OPT, CPT stuff. He's the expert on this. Okay, what do we do? Forget about the old picture. Most of the crew is no longer with us, but it's just a great picture to have. What we do is basically we interpret and advise on immigration matters. We do not give you legal advice. That's what Mark does, because he's authorized by the state to give you legal advice. He's the attorney, we're just advisors. Okay? So what we do is take what the regulations say and interpret them and tell you that this is what it says and this is what you should be doing. Okay? We also cover information about maintaining status, meaning that you must be enrolled and all that stuff, but also employment authorization. Okay? We conduct a lot of orientations, of course, programs such as this as well. And kind of our role is to help shape that campus climate by creating positive collaboration and connections between domestic and international students. So let's begin. All right, the first one is going to be the most important one for you, and this is going to be called Curricular Practical Training, or most of you will probably know it as CPT. This is employment authorization while you're still studying, okay? Let's say you wanted to get a summer internship or work part-time in fall or spring semester. This is what you would be doing. So like I said, temporary employment authorization, but it has to be directly related to your field of study. Right? Basically, it's the curriculum and a connection with your practical training that has to be evident. Okay? If it's not evident, then we'll ask for more information to show that. Who authorizes this? Well, the simplest one is us. We authorize it, but we do it on behalf of the U.S. government. Okay? So the U.S. government has given us that authority, so we scrutinize this information a lot more than normally, okay? Because the U.S. government will hold us accountable for decisions we make. And at times, it may appear that we're trying to be obstructionist by asking you more information, but that's not the point. The point is to make sure that you provide us enough evidence that we can make kind of a logical conclusion. Okay, here's the evidence. This is what it's presenting. We see the connection between your curriculum and your employment. And yes, based on that, we're granting you that employment authorization. Okay? So if you do encounter advisors who say, no, I don't see it, bear with us. Okay? Kind of just have patience and show us more evidence. Okay? Because the idea is not for us to reject. The idea is to give you approval, but enough evidence. Duration, how many times can you, or when can you apply for CPT? You can apply every semester, including summer. Summer is a semester, even though some of you may not be taking classes, but MSU operates on that semester. Okay? So for fall, spring, summer. Now we'll go on that a little bit later as far as what you'll be able to do. Who's eligible? Any F1 student who's been in active full-time status for 1 academic year. Most of you, I take it that's the case. You've all been here for at least 1 academic year. Okay? If you have not, let's say if you came in fall and second semester is your spring semester, but you want to apply for CPT for summer, you will be eligible because by the time CPT begins, you would have completed that 1-year requirement. Okay? When to apply? Anytime after 1 year is complete. Okay, there's a case where I think for most of you this won't apply, but if your program were to require you to immediately start your CPT or internship, then that would be an exception to this rule. Start date of employment, there is no fixed start date. It all depends on when you find the employment, when does the employer want you to begin, okay? The only thing, one caveat, you want to remember this is that you cannot work, even for a day, an hour, a minute or so, without employment authorization. Okay? So you get the authorization, then you begin, right? Permitted hours, this is the important part here. So, whilst for summer and spring semesters, generally you'll be allowed to work part-time, up to 20 hours per week off campus. If you wanted to find, let's say if you've got an assistantship for half-time, you wanted to work additional 9 hours or so on campus, you could do that also. So you do a CPT for the 9 hours, that's still part-time, okay? But you'll be capped to a total of 29 hours of employment time by MSU. Okay. There's a lot of information I'm giving. I just want you to remember the key points, right? Because there's a packet, whatever I'm talking about, there's a packet available on the OISS website that covers everything in detail. And you can work full-time, meaning more than 20 hours per week during summer and any of the vacation times, like winter vacation. If you wanted to work that time, you could work full-time as well. Okay? Who here is on ABD right now? All but dissertation. Okay, so there are 3 people here. What that means is, what that means is, once you pass your comprehensives as a PhD student, that information is sent to the registrar by your department saying this person has successfully passed their comprehensives, and they're on there, they have nothing to do but their dissertation, all but dissertation. When that occurs, 1 credit of dissertation makes you a full-time student as an international, okay? With that, we will even allow you to be a full-time CPT authorized for fall or spring, okay? Now, most of you probably won't do that, right? Unless it's gonna have such a direct bearing on your dissertation that you need to do this extra, whether it be research or actual work, in order to be able to tie and make a strong dissertation, okay? But at that point is when that full-time comes in, but normally, just part-time for fall and spring, okay? Does that make sense so far? Am I going too fast?
May I ask a question?
Sure.
As long as we are eligible, how many times can we apply for CPT?
That's a great question. As long as you're making academic progress, okay? If we see that you're delaying your graduation for sake of employment, we're not going to authorize that. Most of you, I doubt, would want to linger and delay PhD, right? Unless you're a glutton for punishment. If you like to be punished, okay, you'll probably end up taking longer for, but most of you are not going to do that, right? So as long as you're enrolled, you're in active immigration status, right? And you're making progress towards the completion of your degree, you'll be authorized.
I have a question.
Yes.
So, for cases where you started working, so I had a situation where I was working full-time in the summer, now it moves into the fall and it has to be capped for the same amount of work to be paid less. Could you then apply for CPT for something you already would have begun to make up for the hours if you were in in ABD?
For makeup for the hours for ABD, I don't know.
To be able to, I mean, to be allowed to do that many hours without capping at 20 because it's a regular semester.
No, if it's on campus, okay, if you do a CPT on campus for MSU, you will be capped at maximum 29 hours, okay, because that's what MSU wants you to do, okay? MSU has put that your number one priority is to be a student. If you're working more than 29 hours, you're not going to be able to focus on your academics, okay? But if let's say you were working summer semester, you were doing a CPT full time, you were not ABD, but starting fall, you became ABD, okay? You could continue doing that CPT full time or another CPT full time. Again, if you present the evidence that yes, I can see the connection to your curriculum, yes, you can continue doing that. But you file per semester. Spring, you file. Summer, you file. Fall, you file.
And it can be any time within the semester?
Yes. Okay. Yes. Any time. Right. So let's say if you wanted to file tomorrow, right, and your CPT began in 3-4 days, sure. You could file in March for it to be March 1st to begin in March 7th. The only thing is your CPT will only go until the end of the semester. Why? Because your curriculum stops at that point for that semester. We're linking the semester and your CPT together. So must be, that we spoke about, must be full-time, right? Be currently enrolled. There's an exception for summer. Summer is a vacation semester, you're not required to enroll. Okay, in that case, you've got to be enrolled for fall. Okay? That makes sense, right? So if you want to do a CPT 2015 summer, you've got to be enrolled either for the 2015 summer semester or for fall 2015 semester, right? And then you link that course that you're going to be doing the CPT for. Again, everything has to be in your field of study, right? So if you decide to take, you know, an extra class in art and you're trying to do some work, you want to do some CPT in art, but your major is physics, I'm going to have a hard time seeing that connection. It does, trust me, it happens that stark also, I've seen it. You know, people are trying to convince me, I'm going, no, sorry, I don't see the connection. Okay? But usually, what will you do? You'll talk to your professor and say, hey, I want to do CPT, and I need a connection to show that this is connected to my curriculum. And your professor will help you show that, yes, this is the connection. Because we're not experts in every field. If you came to and spoke to me about, you know, educational technology, or if you spoke to me about communication, yeah, I'll be able to tell you. But if you spoke to me about any other field, I'm an outsider looking into your field and trying to draw a conclusion based on the evidence that you present. This is very important. I usually get a student who does not do this at least once academic year. Have work authorization before you start working. There's no excuse, unfortunately, if you start working and you don't have employment authorization. Okay? And it usually doesn't happen with PhDs, but just beware that if you do this, we have no other recourse but to terminate your immigration status for failing to do that. Okay? And this is very serious. That's all. Application time, I would say there are two things. How long does it take for me to process the paperwork is 24 hours. When should you bring your application to OISS? About a week before. If something is missing, you come in today, I review the application, something is missing and you want your employment to begin tomorrow, guess what's going to happen? It's not going to get approved, right? So give yourself enough time where if something is missing, you have enough time to get it back and then get it approved, and then you can show it to your employer, right? What does that do? That also shows to the employer you're a serious person who plans ahead as well. If something comes up, discuss with your employer and say, look, something came up, or you know, I got the offer really late, I'm going to go in. Hopefully I should be able to start. on time. Cost-wise, there's technically no additional cost. If you're taking a course already and you're showing me the connection, well, you don't have to sign up for any additional classes just to do CPT. Okay. Again, students can tie the work opportunity to the course that they're currently taking. I think we've spoken about this, that curriculum and practical training connection. You don't have to enroll again. This is, the packet itself is very simple. It'll probably take you maybe about half hour at the most if you were to take coffee breaks to do this. Okay, it's a one-page application. All right, so that was while you were studying, before your completion, right? I keep switching between graduation and completion. I want you to remember one thing for you, since you guys are PhDs. Completion for you means when your curriculum stops. In this case, you can do your CPT up till the date you do your defense. After that, no more CPT. Okay? Make sense? Because you've defended, now you're just going to do corrections. That's it. Right? After graduation or after completion of the program, this gets a little bit more complicated because the U.S. government gives you more options as to what constitutes completion. Okay. Again, temporary work authorization directly related to your field of study. So if you're a physics major, field of physics. Okay. Engineering major, field of engineering. Whatever you basically your degree you're getting, that's what you have to connect it to. This is authorized by the U.S. government. Okay. USCIS is what you'll usually hear the acronym, but it's the United States Citizenship and Immigration Services. So what you do is you actually compile the paperwork, mail it to the US government, okay, and get an approval. What we do in that middle part is kind of be the person who checks your application and gets you a new I-20 to make sure you mail everything away. Duration, OPT, optional practical training, is granted for 12 months. Okay, most of you don't want to have it for 12 months. Students who are in STEM majors, science, technology, engineering, and mathematics, will have an option for an additional 17-month extension on your 12 months. So you could potentially get 29 months of employment authorization. We'll cover that also. Who's eligible? Again, full-time students who've been maintaining status, right? If you fall out of status, well, obviously you're not going to be, or may not be eligible for this, okay? If you fall out of status, you really need to come and talk to us. That, again, that's a rare thing for PhDs. Because once you're an ABD, one credit will make you full-time, right? So as far as enrolling classes, that shouldn't be a problem at all. How soon can you file for this? Up to 90 days before your completion date. Okay, program completion date. What does that mean? Program completion, again, depends on when your curriculum stops. The OPT packet has a chart that talks about and shows you what that means, okay? So I want you to take a look at that when you come to that point. But you can apply as early as 90 days prior to that date, completion date. Why 90 days? Because it can end up taking up to 90 days to get an approval. So plan ahead and get it in early. That way one thing I tell students, get it off your plate. You don't have to focus on this. Focus on academics once you're done with this. And then all you're doing is just waiting for the employment authorization to come back. It's pretty high. You know, I rarely get students that this OPT is not approved, okay? Unless they fail to provide all the proper documentation. If you do that, let's say something is missing, the government will mail you a letter saying, please send us this information. They'll hold that process. If you fail to do that, then they'll cancel this, okay? That's the most common one that happens, but it's a very, very high percentage of approvals. Again, the government is not here to say, no, we don't want you to work. We do want you to work, but give us the appropriate paperwork in the appropriate time frame. So we'll go a little bit more into this one. Start date, you get to decide what the start date is. Okay. But it must fall within a 60-day period of after your program completion. So let's say your program completion is going to be May 8th. After May 8th, you have a 60-day period with that range. You must decide when I want my OPT to begin at the time of application. Okay. Again, this information is also covered in the OPT package. Simplest thing to maintain status in this, you got to work in your field of study, you've got to work at least 20 hours per week. So there's a minimum, there's no maximum. Okay? You can work for multiple employers at the same time too, as long as all employment is in your field of study. Okay? Sometimes it does happen that students will work for 2 employers. Again, recap, optional practical training, 12 months of authorization. You've got to work at least 20 hours per week in your field of study, right? That's a simple one. The 17-month STEM extension. This, again, like I said, was anybody who's got a STEM degree and it's been, what's going to happen is on your I-20 page 3, you will see in the upper left-hand corner, there'll be a 5-digit code. There'll be 2 digits, period, and then 4, I believe. Okay, or 6, something like that. You'll see that code, the CIP code, which is the Curricular Instructional Program code. What that's doing is taking every institution has a different name for their degree or their program, but they must all fit into the education department's code. Okay, that's the code that appears on your I-20. So sometimes the name of your program listed on the front page of your I-20 may not be exactly what it's listed at MSU. But don't worry about that part. Okay, that's the government's definition. So as long as that degree falls within the STEM, then you'll be eligible for this 17-month extension. Typically, you want to start applying about 4 months before your current OPT finishes. There's a separate packet for that, and there's certain other requirements for that. Okay. Don't focus too much on this. On the CPT and OPT is what you need to focus because that's what you'll be doing first. Anybody here on a J visa? Okay. I take it you guys are already doing academic training then, right? Yes? No? What's your employment authorization?
I'm doing my postdoc.
Okay. Well, that's what you're doing, but your employment authorization comes via academic training. So you've been authorized to do a postdoc. Okay? Right?
Yeah, everybody might not know the technicality of the...
Okay, I will try my best. That's why I put that caveat that I'm an F1 advisor. Actually, there are J advisors as well. Okay. But if you are a J1, you should be authorized for academic training. This is a fairly easy process, and it's done by either your if you are on RJ paperwork, we would do that for you. Okay. If you have another sponsor, that's the person that's going to, or that organization that's going to do that employment authorization for you. Okay. The thing is, you get a much larger right away. You can have up to 18 months. And then you've got that pre and post graduation one as well. So you've got a bit more flexibility. Let me go back to that pre and post. It reminded me, OPT is done pre-completion and post-completion. Okay. At MSU, we only process post-completion OPT. And some students ask, why? But I want OPT. And what we say is, we've got a fairly flexible CPT. Use that first. Because if you use up a part of your OPT, if we were to authorize you to do pre-completion OPT, you won't have much OPT left once you graduate. There are institutions who restrict people from doing CPTs, and they can do that. That's up to them, okay? And at that point, those institutions will say, well, no, do pre-completion OPT. but nothing to worry about as far as pre-completion OPT and MSU. Okay? I'm not going to go too much into the J because I don't want to give you wrong information. So I apologize for that. But we've got J advisors. If you have questions or if you feel that I'm not sure if I've been authorized, well, first thing is it should be on your DS 2019. Okay? And if you still have questions, come talk to us. Even though you may not be on our paperwork, you're still here working for MSU. We're going to give you the right advice. When you do come to OISS, just say, look, I'm on a J visa. I need to see a J advisor. No problem. All right, so takeaways real quick. No employment authorization required if you're just going to work on campus, right? Up to 20 hours, you can continue working. Employment authorization is required for off-campus at any time. Okay. And of course, as you saw, F&J visas have different options as far as employment authorization. F1 visa, while you study, CPT. Once you're done, OPT. And make sure you always, if you have any concerns or any questions, come talk to us. Okay? Email, phone call, make an appointment, walk in, no appointment, advising hours, right? So you walk in between 1 and 3, Monday to Friday, don't need an appointment, quick question, no problem, we can help you out. And the OISS website has a lot of information. Okay? Some of us help maintain that website so we know that there's a lot of information. So at times we will direct you. And I know when students have not read it, even though they claim they've read it, because they're asking fundamental questions that are in that packet. And I will usually say, read the packet. Read the packet, because I want you to not waste your time asking fundamental questions, but ask more probing and specific questions to your situation. So you're maximizing your time with me at that point, or with any advisor. Okay?
So excuse me, another question. So once we have done the graduation, so how much we have time to apply for OPT? I mean, how long you can stay in the US after graduation?
If you don't apply for OPT, 60-day grace period, okay, generally, unless you're going to have another program that starts within five months of that. If that's the case, at that point you should be talking to us because there are various different things we'll be doing, okay? Depending on where you're going to be going to.
Do we have to change the visa status when we're applying for OPT, CPT, or we are still holding the F1?
You're still in, remember OPT, CPT is not a visa category. It's still part of that F1, right? These are your privileges you get. It's not a right, but it's a privilege. Right? It's not automatically granted to you. You have to ask for it and be given permission.
In between your comprehensive and your defense, if you have an offer for a full-time job, what is the best way? Obviously, it will be more than the 20-hour limitation for CPT.
It'll be a full-time CPT.
Okay.
Right. So you could do that as long as I can, before your defense, I can still see that connection, and you can prove to me that there's a connection to your curriculum.
Oh.
Right.
Okay.
Okay.
So that's
it does happen with PhD students.
Okay.
Yes. But again, that date of defense, that CPT ends. And if you want to continue working, then start planning ahead and start applying for OPT based on that defense.
Oh.
Yes.
What are e-verify employer or companies that you mentioned?
I don't think I mentioned, but.
There was some kind of
Oh, yes. The E-Verify are certain, that comes into effect when you are applying for the 17-month extension, okay? So what the US government has said, yes, you're eligible. We want people in the STEM field to work extra and all that good stuff. But the thing is, you have to work for an employer who's E-Verified, gone through the certification by the government, and then there are some responsibilities that the employer has of disclosing information about you to the U.S. government. Okay, and there is actually a list on the USCIS website, and correct me if I'm wrong, but they can find that list on the USCIS website, uscis.gov, of e-verified employers. Okay, it will not give you their code, the e-verify code, but it will say, okay, let's say if you're trying to apply for Procter & Gamble or the e-verify, and most large company corporations are, but if, let's say if it was a small company you're working for, you're not sure, they'll be part of that list. Or you can always call them and say, are you e-verified?
And I have seen companies that will become e-verified, small companies that will become e-verified because they want to keep their international talent. So just because a company is not on that list doesn't necessarily mean that they're going to become e-verified.
But this is, most companies that want to compete in the world nowadays are e-verified. Think about the talent pool you're taking away if you're not e-verified. So they will, most of them will do it. And like Liz says, small companies that may not be aware, you bring awareness, all of a sudden they may say, this is actually a good thing. Okay, so real quick thing about volunteering. You know, I get students who ask, can I volunteer off campus? And this is a very important question. It's particularly when you're studying, you get an opportunity to volunteer. Volunteering is you've got to, first thing I'll say is before you even start volunteering, bring in that information, say what is it that you're doing, okay? If it looks like more like a CPT that you're working and you will get some kind of a compensation, that's not volunteering anymore, right? You go feed the homeless, yes, and you get zero compensation, yeah, that's volunteering. But there are specific definitions that the government has. At that point, come talk to us and we'll go to that. But don't automatically assume. Especially if you're going to put it on your resume, I would say it's better to be cautious and go through a CPT process than to have it come back later and haunt you and go, oh, I should have done it. You don't want to be in that, because you want to guard your status. That's your responsibility. Again, once you graduate, unpaid work, when you're on OPT, you don't have to be paid. Okay, as long as you're working in your field of study, you're still maintaining status according to the OPT. That's why I didn't mention getting paid. All I said was work at least 20 hours per week and in your field of study. Okay? But obviously most of you want to get paid. Right? Unless you're well off, then that's fine, you do it for charity, that's okay. Again, if you're not sure, any questions, just come, talk to us, email us. It's better to have that done. I know you may feel that, oh, it might be a dumb question or something. No, trust me, it's not. If it protects your status, there's no such thing. I would guard it. I would make sure I ask plenty of questions. Thank you. And contact, well, all of you know where OISS is located, right? Mm-hmm. International Center 105? Okay. All right, that's my take on it. Hopefully, like I said, if you do anything, if you don't remember anything else, go to the OISS website, get the information, or talk to us. And Mark will take over.
So I'm going to talk about what happens after school. Again, my name is Mark Topoleski. I was a graduate of Michigan State in 1993, economics major, and I went to law school at Vanderbilt, and I'm managing attorney Bellis Porter, which is an immigration law firm. We're based in Troy, Michigan. But we help people from all across the state and all across the United States. What we're going to talk about today is, again, what happens after graduation. And first, I like to just highlight the impact that U.S. PhDs make on our economy. You're some of the best and brightest in the world, and I think it's fortunate if we can have you stay here in the United States and apply what you learn And it's a proven fact that the knowledge that you bring and contribute to our country makes the economy better. We're also going to talk about how to transition from an F1 to an H1B, which is really the most common work visa category available. And we'll also talk about transitioning from J1 to H1B, because I only have a couple J1s. And then we'll talk about green card or permanent resident status options. And then also, you may have seen back in November, President Obama announced his executive action on immigration, which had a lot of proposals that had to do with illegal immigration, but it also had a lot of proposals that will help with employment-based immigration topics, and we'll talk about that as well. So one, I love sharing these stats because I think it just shows how impressive you all are and what you do when you leave Michigan State. But again, 50% of all PhDs in engineering and 45% of the PhDs in these other areas are awarded to foreign-born students. When you get out in the workforce in these very high-tech, high knowledge-based fields, again, the PhDs are the people holding a very foreign-born PhDs are holding a very high percentage of these positions. Immigrants and PhD students are also very entrepreneurial. You get out into the economy and you don't just sit around, you guys do things. You start businesses, you start companies, and you create jobs for America. I think that's amazing. Michigan ranked 3rd in the nation as far as how many businesses were formed by foreign-born students. I think that's amazing. Also, almost a quarter of the patents in the United States are filed by immigrants, and in Michigan, over 35% of the patent applications are filed by immigrants. And immigrants are more than 6 times likely than a person born in the U.S. to do that. So that's very impressive as well. And again, very entrepreneurial and very likely to start a business. So for all those, what we're going to talk about, because sometimes it may seem, I think it's so great to have you here and to have you be able to stay and contribute to our nation and our economy. Sometimes it doesn't feel that way though when you're navigating the system. So we're going to talk about what the system is and how to get through it as best we can. So just a general background of the U.S. immigration system. People can really only be here in 4 different very broad statuses. You're either here in a temporary visa status, which is called non-immigrant status, or you're here as a permanent resident or green card holder, and that's an immigrant visa. You can be here as an asylee or a refugee, so you're fleeing the country because of dangerous conditions there, or you're a U.S. citizen. A lot of people think green card and citizenship is the same thing, but it's different. You apply for citizenship after you've been a permanent resident for a certain period of time. It can be a maze getting through the immigration system because you have to deal with so many different rules and regulations and so many government agencies. You're dealing with not only the USCIS, but the Department of State, the Department of Labor, and they're not always the easiest agencies to work with. On the temporary visa side, there are more than 40 different temporary visa categories. And basically, they're all based about what the activity is that you're going to do. So certain visas are authorize you to do just certain types of work. What we're going to talk about today is the H-1B specialty occupation visa, which is really the most widely used visa for professional employment. We'll talk a little bit about the J1, the O1, but there are so many visas available, but usually for people coming out of a PhD program, there's just going to be a handful of options for you, but that's what we're going to talk about. So most of you, the majority of you here are here on F1, and when you leave Michigan State, you may look to get a job, and to do that, you might need an H-1B visa. An H-1B visa is for specialty occupation workers, and those are defined as people who are working in a job that normally requires at least a bachelor's degree as a minimum educational requirement. So most of the jobs that you're going to be taking are going to be specialty occupations because you're going to be in PhD level jobs. But just to give you an example, the specialty occupation is defined by the minimum requirements of the position, not your qualification. So the example I like to give is registered nurses. So registered nurses, a lot of registered nurses now have bachelor's degrees, but that's still not the minimum requirement for that occupation is still only 2-year associate's degree. And so because the requirement for the occupation is less than a bachelor's degree, the nursing occupation does not qualify for H-1B, even though you may have a bachelor's degree. And it's the same with any other occupation. You can have H-1B status for up to 6 years. Typically, you can get it in 3-year increments, 2 increments of 3 years each. And you can, in some cases, get an extension beyond the 6-year period, but only if you are pursuing a green card and you have reached certain milestones in that green card process. Right now, H4 spouses, H4 is the dependent category for H-1B visa holders. H4 spouses are not eligible for work authorization. We're going to talk a little bit about this in the executive action update, but there is a proposal to change that and maybe allow some H4 spouses to work. But right now, they are not eligible for work authorization. Another sticky issue with the H-1B visa is that there is a quota as to how many visas are available in a given year. The quota is around 65,000, give or take. The Immigration Service runs on a fiscal year that goes from October 1st to September 30th. And so this coming October, we'll be starting fiscal year 2016. And so in that fiscal year, the USCIS can only issue 65,000 of these H-1B visas. The problem is, the last 3 years now, they've received more than 65,000 applications in the first week of filing, so they're gone in 5 days. I think last year they had up close to 150,000. So almost 1 in 2 or 1 in 3 people are only able to get the H-1B visas. There's a lot of proposals in Congress right now to change that because it just is not a very good system where we're basically relying on a random selection process to select who gets our H-1B visas every year. But until Congress takes action, which they are not very good at doing, we are stuck with this system. So right now we're leading up to April 1st, which is for immigration lawyers is the busiest time of year because we're trying to file everybody's H-1B application for this H-1B cap. Now, there are certain employers who are exempt from the cap. And so if an employer is exempt from the H-1B cap, that means that they can file H-1Bs anytime during the year. They don't have to worry about whether there's numbers available or not. Cap-exempt employers are going to be institutions of higher education. Michigan State is a cap-exempt employer, so if you work for Michigan State, that you would not have to worry about the cap. Other nonprofit organizations affiliated with institutions of higher education. This one's a little bit tricky, but for example, we have a client who is a teaching hospital in Detroit. They are nonprofit, and they have an affiliation agreement with Wayne State on a lot of different levels, and because of that, they are able to also be considered a cap employer. But the Immigration Service looks very closely at what level of affiliation you have. It has to be a very tight and integrated affiliation with that institution of higher education. Nonprofit research organizations and government research organizations are also cap exempt. When we're filing for the cap and counting those 65,000, there's also a special exemption for individuals who have U.S. master's or PhD degrees. Basically, the way it works is that the first 20,000 applications received from individuals with master's or PhD degrees, they're not counted towards that 65,000. Now, in the past 3 years as well, that 20,000 cap has also been met. So if you as a PhD student are applying for an H-1B, you're going to get a first crack at it by trying to get it through the 20,000 exemption. If you don't get it through that, they then put you in the pot with everybody else, and you get one more chance at trying to get one of the 65,000. So you do have an advantage over someone who just a bachelor's degree educated individual who really only has one shot at it. You essentially have 2 shots, and that increases your chances a little bit. Another issue that comes up with the H-1B cap is something called the cap gap. A lot of times, depending on when your OPT ends, if you applied in after you graduated in like May or June, your OPT probably expires in June. And now the way the fiscal year works is if you apply for an H-1B in April and it's approved, the H-1B is not effective until October 1st. So your status doesn't officially change until October 1st. You can't start working until October 1st. But the problem is your OPT might be expiring in June. So what do you do about that gap of employment? Well, a few years ago, they passed some regulations that allow basically that if a student who was on F1 OPT and it was valid at least through April 1st, and then on April 1st they can show that they have a receipt notice for an H-1B cap application that was accepted, then they can be eligible to have a special extension of that OPT work authorization through October 1st to get them to the point where their H-1B kicks in. You would coordinate that with Hirsch and his colleagues at the OISS, because they're the ones who will log you into their SEVA system and make the edits to your I-20 to make sure you have that authorization. There's a kind of an interesting issue, because this question has come up from a lot of people, but you can't, there's something called, well, on H-1B you can always do what's called concurrent employment. So if you wanted to work part-time for 2 employers, that's allowed. You can work 20 hours for one employer and 20 hours for another. That's fine. That's called concurrent employment. Now I don't even want to call it a loophole, but what the law does allow is that if you are working for a cap-exempt employer, let's say part-time, you're not subject to the cap, so you don't have to worry about these cap issues. But if you wanted to then also get concurrent employment with a cap-subject employer, you're actually still allowed to do that, even though the cap applies normally to that employer. So if you have a kind of a foundational position that's with a cap-exempt employer, that does allow you to do some part-time work with a cap-subject employer. Now, if you stop working at the cap-exempt employer, then you don't have that ability anymore. But Massachusetts is a state who's really looked at this and is trying to use this as an opportunity to retain people who, foreign students who want to start businesses and be entrepreneurs. And they've suggested this program where they will have, a university, they'll screen people for entrepreneurial talent, and then they will offer them a job with their institution for maybe up to 10 hours a week, but then, which locks in the cap-exempt status. And then the person can go out and work for a startup the rest of the time, and that is not counted towards the cap. So it's kind of an interesting strategy, and so if you are a person who wants to start a business or be entrepreneurial, there may still be ways to do it. I was saying we should talk to Michigan State about doing something like that. That would be a great program. One thing to keep in mind with H-1B status is it is an employer-sponsored status. Just like you can't get an F-1 without your university's cooperation, you can't get an H-1B without an employer sponsor. So you can't just go out and say, I'm going to file for one by myself. So an employer has to offer you a job and be willing to file the H-1B application on your behalf. The law also requires that they have to pay for most of those application costs related to the H-1B. So you can't go to an employer and say, I'd like you to hire me an H-1B, but I'll pay for everything, because that's not permitted. The processing times are different based on whether you just file a standard application or use what's called premium processing. The standard applications right now are taking about 3 months, and then the premium processing is available if you pay an extra government filing fee of about $1,200, but then you can get them to issue a decision within 2 weeks. Now, because you're changing status from F1 to H-1B, immigration law says that when you're changing status, you can't start work until the new H-1B application is approved. So depending on the timeline for when you want to start work, that's going to dictate whether you would like to do normal processing or maybe this premium processing. So now the J1, we had a couple J1s. The J1 H-1B transition has some different issues as well. You certainly have all the cap issues to contend with. That still applies to you as a J1. But you may have another issue called 212E, the 212E home residency requirement that you may have to worry about as well. Basically, some J1 visa holders are subject to this home residency requirement, which says that after the end of your J1 training, before you can essentially move into another status or move into permanent resident status, you have to go back to your home country for at least 2 years, and then you can come back, or you have to get a waiver of that requirement. And the basis for that is the J1 is it's called an exchange visa program, so it's meant to have people come here, learn some knowledge, and then take it back to their countries. And so if you want to kind of circumvent that, they have to get a special waiver. Now there are ways that you can, so the people who are going to be subject to that 2-year home residency requirement will be people who receive U.S. or government funding for their education or training. So if you're a Fulbright scholar, you're automatically subject to that. Or if your field of studies is on the Department of State's skills list. The Department of State maintains a list of skills that they believe are in short supply in every country in the world. And if you're working or you're studying in a field that's on the skills list, their preference is for you to go back to your country, apply that knowledge, instead of just staying here. kind of prevent a brain drain from your own country. So if you have government funding or you're on the skills list, you're going to be subject to that home residency requirement. I always tell people, when you get a visa, sometimes there'll be an annotation that says subject to 212E or not subject to 212E. They're not always right when they put it on there, so it's always a good idea to talk to an attorney and make sure that you either are in fact subject or not, because they often get it wrong. But if you are subject to the 212E home residency requirement, there are some ways that you can, if you don't want to go home for 2 years before coming back to the United States, there are some ways to pursue waivers of that requirement. One is through what's called a no objection letter, so you can apply to your home country's consulate in the United States, and they'll have a process where you can basically ask for their permission to have a waiver of this requirement, basically saying, will you let me stay here in the United States without complying with this requirement? Usually that process can take a few months. Some countries are more strict than others as far as issuing those letters. There's also what's called a hardship waiver. So if the hardship has to be a hardship to a U.S. citizen relative, it's not a hardship to you. So if you can prove that having to go back to your country for 2 years would create a hardship for a U.S. citizen relative, a spouse or a child, then you may be able to get a waiver of that requirement. It's got to be a pretty significant hardship, though. It's not just that, oh, we would have to pick up and move. I mean, it would have to be that, a lot of times, a great example is if, let's say you have a child who has a severe medical condition and back in your home country, they would not have the ability to properly provide medical care for that condition. That would be a good reason. Sometimes if you have a spouse who would not be able to be employed or would create a very significant career issue for them, that may be a hardship, qualifying hardship as well. Persecution, on the other hand, that does have to do with you yourself. And so if you're just saying that if I had to go back to my home country now, if there's something going on with the country conditions and something going on with my background, whether it's my religion or any other factor, that I might be subject to physical harm if I had to go back, that would be another basis for a waiver. The last basis is what's called an interested government agency waiver. Certain government agencies can act as a sponsor for individuals for waivers. A good example is the Health and Human Services. For certain people who are working in the sciences, they may sponsor a waiver. Now, I just want to mention really quickly O1, because most of you are going to move probably into H-1B status, but O1 is a possibility as well. The O1 visa is for extraordinary ability. I think you're probably all pretty extraordinary. But this is the Immigration Services criteria for whether someone is extraordinary. A lot of people who are coming out of PhD programs, especially very high-level specific programs, they may be able to show enough of these elements to move into an O1. So if the H-1B cap strategy doesn't work for you, maybe an O1 is a backup option. For the J1s, just keep in mind, even if you do move to O, you can actually move to O1. That's the one category you can move into. But it doesn't alleviate that home residency requirement. So it might allow you to move into an employer and start working in O1, but at some point you'll still have to take care of that home residency requirement. So H-1Bs, J-1s, O-1s, those are all temporary work visas that have some limit on how long you can stay in those statuses. If you want to stay in the United States longer than that, then you may want to apply for what's called U.S. permanent resident status, or the slang term would be green card status. There are really 6 main green card categories. Some require a process called labor certification. What labor certification is, or it's called the PERM labor certification process, that's a process where the employer who's sponsoring you has to show that there's a shortage of U.S. workers in that in their region, that no one is willing, available, or qualified to fill the position. So it can be a tedious process. It requires them to conduct a good faith recruitment in the labor market, and it can be a lengthy and complicated process. But not all categories require labor certification. One thing I didn't mention is H-1B. There's kind of a misconception that people think that for H-1B visas you also have to show a shortage of U.S. workers, and that's not true. For the H-1B, you just have to show that you're working in a specialty occupation and that you have the requisite degree in education to do that. There's no requirement of a showing of shortage. There is, however, in some categories of the green card. So this employment-based preference, first category, or EB1, will include what's called extraordinary ability green card. Criteria are very similar to the O1. There's a category for outstanding researchers, multinational managers. The EB1 categories do not require labor certification. It's a major benefit. EB2 would cover people who are advanced degree professionals. So usually you're either in a job that requires a master's degree or at least a bachelor's degree and 5 years of experience. This national interest waiver category also falls under EB2. We'll go over that in a second. And then EB3 category would be for someone who is a bachelor's in a job that requires a bachelor's and something less than 5 years of experience. EB4 kind of for religious workers, and then EB5 is the investment-based visa for people who are going to invest in the United States. Similar to the H-1B, there are also quotas for the various green card categories as well. But the quotas are, there's a number of how many visas can be issued in each category, and then within that there's also a limit as to how many visas can be issued to a particular country in that category. Right now, countries that send a high number of immigrants to the United States are, those categories are backlogged because there are more people applying for the visas than there are visas available. Individuals born, and it goes by your country of birth, not your country of citizenship, but individuals born in India or China right now are contending with some pretty significant backlogs in both the EB2 and the EB3 category. For EB2, for most other countries, there's no backlogs, and there's no backlog for anybody in EB1. But you know, the backlog is pretty significant. I think right now, for example, in EB3, India is back as far as 2002, 2003, meaning that someone who started the process that long ago is still waiting to finalize the process and get the green card. Now they're able to stay here because of those special extension provisions we talked about that allow you to keep extending an H-1B while you're pursuing a green card, and that's how they're able to stay here. But it's frustrating that they have to wait that long. So the EB1, again, for a lot of PhD students, this could be a viable category for you. As you'll see, the criteria are very similar to the O1, it's a little bit more extensive. Essentially, you have to show that you meet at least 3 of these 10 criteria. The interesting thing about EB1 extraordinary ability is this you can self-petition for this. So you could either have an employer sponsor file an application for you, or you could file an application on your own, just proving individually that you meet all of these, or at least 3 of these criteria. Now, there's a second category under EB1 called outstanding researcher. Now, first of all, this one has to be employer sponsored, so it can't be self-sponsored. And you have to be working you have to have 3 years of research experience, and you have to be working in a research-oriented employer in a permanent research position. So if you're in kind of like a short-term grant-funded position, that's probably not going to qualify. If you're at a company that really doesn't have an established research department, that's probably not going to work either. But if you are with a qualifying employer and you have a qualifying experience and you have a long-term permanent position, then you may be able to get a green card under this outstanding researcher category, which has less strenuous requirements. You only have to prove 2 of these 6 criteria, and even the strictness of the adjudications tends to be a lot more lenient in the outstanding researcher category as it is compared to the EB1 extraordinary ability. So it can be a really good option for some people if you're in the right situation. Also, now this is under the EB2 category, is something called a national interest waiver. Immigration terminology can get confusing sometimes, but here, in the J1 context, we were talking about waiver in the sense of a waiver of that 212E home residency requirement. The national interest waiver, the waiver means a waiver of the need to do a labor certification. Because normally in the EB2 category, the employer would have to do that labor market test and show a shortage. But for some people who can show that they meet this national interest waiver criteria, the need to obtain the labor certification is waived. So waiver is used in 2 different ways between the J1 context and this context. But here, essentially, if you can show that you're doing some work that is inherently benefiting the United States in some very special way, you may be able to apply for a green card under this category and skip that labor certification process, so save you some time and save you some money in the process. EB-5 is a real hot topic right now. It's always been around, but it seems to be being used much more frequently lately. And this is an investment-based green card. So any foreign investor who wants to invest money in the United States to start a business, if they invest up to $1 million, then they can get a green card under this EB-5 category. If they're investing in a business or an investment opportunity in a targeted employment area where unemployment rate is 150% of the national average, then they can actually get by with only investing $500,000. Essentially, the way it works is they obviously very closely scrutinize your investments. You have to have a solid business plan. Sometimes there are opportunities to invest in groups that have already kind of set up a qualifying investment. Sometimes that can make it easier, or you can just do your own individual investment. But they will look very closely at your business plan, whether it's a legitimate business, where did the money come from that you're investing, the source of funds is a very important issue. And then you have to show that within 2 years that you'll be able to create 10 new jobs for U.S. citizens or U.S. permanent residents. So if your initial application for an EB-5 is approved, you'll be granted a kind of conditional permanent resident status for 2 years, and then after 2 years, to have that condition removed and to be a regular permanent resident, you have to show that your business has grown and you've created these 10 jobs. And if you have, then you will become a regular permanent resident. Now, there's 2 ways to essentially get green cards. One is through employment or kind of work or investment, and the other is through family relationships. So on the family-based side of immigration, there are basically these 6 categories of relatives who can sponsor another relative for U.S. Permanent resident or green card status. So immediate relatives, the nice thing about that category is there's no quota for how many visas are available for immediate relatives. So if I'm a U.S. citizen, I can sponsor my spouse, I can sponsor my child as long as they're under the age of 21, because once they're over 21, they're not considered a child anymore. And I can sponsor my parent. And so there's no backlog in this category. You can apply straight away, and typically in as soon as maybe 6 months, you can have a green card for that relative of yours. One key thing to point out is we get a lot of questions about, well, I immigrated here, I'm studying at Michigan State, but we had our 2 kids here. Our kids are now citizens. And the question is, well, can they sponsor us? Can they help us in any way? They cannot sponsor you as they're a U.S. citizen, they cannot sponsor you as the parent for a green card until they reach the age of 21. So up until that time, unfortunately, they're not an immigration benefit to you, other than in that J1 hardship waiver context. If you have a U.S. citizen child, that may be a basis for a hardship claim. But for sponsoring you for a green card, they're not going to be able to do that until they're over the age of 21. And then these other preference categories do have quotas, and the quotas actually are quite lengthy, going from a couple years wait to sometimes more than 10 years wait. So the F1 and the F2 would be unmarried sons and daughters of U.S. citizens, and then F2A is spouses and children of permanent residents. So a permanent resident can also sponsor their spouse for a green card. But one thing to point out here is, let's say if you're applying for a green card and you're also thinking about getting married, if you can help it, and I know you don't always plan love around immigration, but it is Valentine's Day. But if you can, the best thing, if you can help it, it's much better to get married before you get a green card. Because if you get married before you get a green card, then your spouse is your dependent, and they actually can get a green card with you through the same process. If you become a green card holder first, and then you get married, now you have to sponsor your wife or husband under this category, and there's a several-year waiting period to do that. So it's much better to get married before you get a green card, so you can both become green card holders together, because if you wait, then it can take much longer. And then this is unmarried sons and daughters, married sons and daughters of U.S. citizens, and then the last category is brothers and sisters of adult U.S. citizens. And like I said, that's probably like a 10-year wait. I think for one of these categories, for the Philippines, the priority date is back in the 80s. That's crazy. Now, as I mentioned in November, President Obama announced his executive action. I guess the one thing to highlight here is the fact that he threw out a lot of proposals. A lot of those proposals are very good, but none of them have gone anywhere yet. I mean, President and Congress are still fighting over immigration, and it's very unclear at this point whether these things will become effective, and if they will, when they will become effective. But there are some things that were mentioned in there that are very positive. Like I said, about half of the proposals he made have to do with people who are here without legal status. So there are some ways to something called deferred action to help people in those situations. But for people who are here in a legal status, there are some nice employment-based proposals that were put forth. It's just going to be, we just don't know yet when they're going to become effective and what the details are, because it was the details given were very broad and general in the announcement. But one of the proposals has to do with allowing some H-4 spouses to get work authorization, which would be great, because for the longest time they haven't been able to do that. And a lot of times, the H-4 spouse is, just as talented as you are, and again, would like to get out and contribute to the economy, but the ability not to work has been holding them back. What the proposal would be is not that every H-4 spouse gets work authorization, but only H-4 spouses of H-1B principals who have started that green card process. And if they've started that green card process and reached certain milestones, they're going to allow those H-4 spouses to also apply for work authorization. Again, we don't have all the details. There was, the last I heard, that they had said that maybe this might be coming out towards the end of February, but we'll still see. It was, right now they did what's called the proposed regulations. They got comments, and now they're assessing those comments. And then the next step would be to issue a final regulation. And we are hoping to see that maybe within the next month or so, and then we'll have a lot better idea of who it will help. There was also a proposal to expand the OPT extension provisions, basically in two different ways. So one, as Hirsch mentioned, for certain individuals, you can get this beyond your normal 12-month OPT work authorization. You can get up to an additional 17 months, but only if you have a STEM degree. One of the proposals is that they would expand the number of degrees that would qualify for this, so maybe some degrees outside of STEM might be able to qualify. And then they're also talking about even expanding that 17 months further. So there may be the ability to get even longer periods of OPT work authorization in certain situations. They've also talked about expanding opportunities for inventors, researchers, people who want to start up companies and be entrepreneurs to help foster that. This is probably the one that to me is the most interesting, but it's also the proposal that was the most vague. We really didn't have a lot of details of what they are planning here, but I like the thought. It's a good thought, and if they actually did something in that regard, I think that would be wonderful. They also are talking about making some more flexible options for people who want to change jobs while their green card application is pending. That process is called porting from one employer to another. The way that the green card rules work, sometimes if you have started a green card process but haven't finished and you're stuck somewhere in the middle, it can be challenging to move a job, because at certain points of the process, if you move jobs, you may or may not be able to transfer that H-1B or the green card process over with you, and therefore you might have to start the whole process over again. And so what they're talking about, and again, that becomes an issue when, especially if you're a person born in India, a person born in China, where you have started the green card process, but it may be many years before you get it. You don't want to be locked into one employer. You'd like to have the ability to move, and they're talking about making that a little bit easier, which would also be great. And then lastly, they've talked about streamlining the immigrant visa process, how they count those numbers for the quota. There's some talk about maybe only counting principal applicants, not the family members, so that frees up some numbers for different people from different countries. Maybe looking at other categories where we have unused visa numbers and putting them into other quota categories. That might help with some of the visa backlogs for individuals from India and China. And then also, just making the perm labor certification process more user-friendly. It's a really backwards process, very cumbersome, and if they could make it fit the real world a little bit better, that would be a welcome change. So that, I talked pretty fast, so that's why I wanted to make sure we covered some of these topics, because in talking to the folks at OISS, they said these are a lot of the issues that were very relevant to a lot of the PhD students. So hopefully I didn't talk too fast, but I was able to hit on some of the important points. And if you ever have any questions on these issues, obviously just feel free to contact us. We're very open to talking to people. We don't charge for phone calls, so just give us a call. Give us a call. Send us an email. We're more than happy to talk to you and understand your questions and your issues, because everybody's situation is very different, and it can be helpful to kind of talk through and see what your options are. And the biggest piece of advice I would give you is just plan ahead. The immigration process, it's a long journey, it's a long road, and it forces you to think far ahead. But the more advanced planning you do from an immigration perspective, the better off you're going to be. The worst situation you want to be in is where you've left yourself very little time to try to execute an immigration strategy, and then you're kind of rushing to try to get things done, and maybe you haven't even left yourself enough time to implement the right strategy. So plan as far in advance as you can. Start thinking about what your career path is, and go talk to an immigration attorney, and just have somebody who can lay out the options for you looking in the future. I think you'll be better off. So thanks again for letting me talk to you, and hope everybody has a good Valentine's Day.
For more information about PhD Career Services, please visit www.careersuccess.msu.edu/PhD careers. Thanks for watching.